All right, folks, you know what time it is. Welcome back, welcome back, welcome back, as the song goes, to another fun-filled evening of pre-licensing. It's your Friday, technically your Friday, but it is in fact Wednesday because this is your last day of this week until next week. So we've got lots of fun-filled things to continue to go over and get you fine folks well-versed in the wonderful world of licensing education. So you can pass a test, so you can pass another test, so you can get a license. That's the plan. So, missing a few of our peers as per usual, but I'm sure they'll be in here just momentarily. I know that 6 o'clock comes fast with all the other fun-filled and exciting things y'all got going on in your lives. Just like I always like to do, let's just open it up. Any questions, comments, concerns, trials, tribulations, or otherwise that I can touch on for you fine folks before we get into the material of the evening?
Sam,
Yep.
in a minute you may see two of me in here. My laptop is acting stupid. It did an update and I don't know what it's doing. It won't allow me back into Zoom. So I have a tablet so I can at least be on while I'm trying to figure this out.
No worries.
So if it signs me in twice, that's why.
Okay.
I don't know what
As long as you haven't cloned yourself, we're okay.
I don't need two of me.
Listen, that's what I say. If there was two of me, the world would be in for some problems, all right? I'm enough of an issue on my own. I hear you. Anything? Anything y'all have seen, concerned, want to talk about before we kick off the day? The night? Whatever you want to call it. Cool. Then let me do as I tend to do and remind you where we're at and kind of recap some of the things. Folks, we are currently about to, well, tonight we will wrap up, as weird as it is to say, the halfway point. Now, it's really more than the halfway point because the other materials, there's really only 3 more super crazy in-depth chapters, right? The financing, the valuations, and we'll call it property management. The rest of them are a lot shorter and more succinct chapters. So while this is numerically around the halfway point, it is past that for all intents and purposes. So we're talking about, or we left off talking about basic contract law. And so we started discussing, the things that contracts could be, okay? Contracts can be express versus implied. What does express mean? Stated. Don't ever confuse that. Everybody likes to, for whatever reason, and some people like to lock on oral, some people like to lock on in writing. It's neither. Both are express, but it doesn't concrete mean one or the other. It just means we've stated it in some way, shape, or form, whether it be in writing or orally. And then what does implied mean?
By your actions?
There you go. It was suggested or created by our actions. I did this, you did that. We had this mutual understanding that this was what's going to happen. The example I gave you under basic contract law was sitting down and ordering at a restaurant. You know that you have to pay for that. Nobody has to state that. That is an implied kind of agreement. So then we got into other things that contracts could be. Contracts can be executed versus executory. What does executed mean?
Like all parties have fulfilled their respective obligations to the contract, right?
Say that one more time.
All parties have fulfilled.
There you go. Yeah, fulfilled. All parties have fulfilled their obligations. You did what you were supposed to do. I did what I was supposed to do. It is dunsies, right? Completed. Everything and anything. That's right. So what does, if executed means completed, fulfilled, done, what does executory mean?
there's something remain to be done by both parties, one or both parties.
Something remaining to be done by one or both parties. That's exactly right. It's not been completed. So let's compare that to real estate. If we were dealing with real estate and we were under contract, but we haven't closed, transferred ownership yet, that would be an
It's me. I'm sorry. Thanks.
Stephanie, you're ruining my life. Ah! An executory contract. Okay. So executed versus executory. Then we got into bilateral versus unilateral. What is a bilateral contract?
Two people, two promises. Well, they're all two people. But
Well, yeah, there you go. They're all at least two people, right? I told you, you really can't have a contract with just one person. But there are two promises. A promise for a promise. It's two-way exchange. I promise to do this, you promise to do that. Most contracts are bilateral contracts. Most are. What does unilateral mean?
Two parties, one promise.
Yep, yet again, we gotta have two parties, but there's only one promise. Okay, this is where that if comes into play. If this, then I promise to do that. So there's only one promise being made. Now, what was the most common example of a unilateral contract in the real estate world that we talked about?
an option to purchase.
An option to purchase, which is where you would basically buy a period of time to decide if you in fact did want to purchase the property, but you would have already have negotiated what you're going to purchase the property for. And so basically the seller promises to sell if you decide to buy, but you have never promised to buy, which is why an option to purchase is a unilateral contract. What you got, Jacob?
Isn't kind of just listing your house in general, wouldn't that technically be a unilateral contract? Because you're saying, if anybody gives me this much money, I'll sell you my house.
The problem with that is you can't think that way because remember, the seller is not obligated to sell. The seller has not made a promise. They said, I'm marketing my house for this. But remember when we talked about the agency contracts? If we produce a ready, willing, and able buyer at terms acceptable to the seller can say, no, I'm not selling it. They've never made an actual promise to sell it.
I'm going to be so honest with you. You cut out for the last 30 seconds. I don't know what happened. My whole computer froze.
Okay. I said you can't think like that because, number one, we're talking about contracts and you're talking about marketing a property for sale. And the thing is, the seller has never promised to sell. It's marketed at that price. It's listed at that price. But remember when we looked at the listing agreement, even if we bring a buyer at that price, is the seller legally obligated to sell it at that price? No. So they've never actually made that promise. Now, have they made the promise to pay us if we find a buyer at that price? Yeah. But they've never promised to actually sell it at that price. So I wouldn't think of the marketing of a property as a unilateral thing, just so you don't get confused in some of the aspects that you can see testable. So then we got into some other big pieces, right? Valid, voidable, and void. What does valid mean?
Contains all essential elements.
Contains all the essential elements under basic contract law. That is exactly right. Hold on one second, folks. Let me do something real quick here.
Make nice dinners.
Wait, I don't think anybody does at this point, do they? With all these classes going on. Sorry about that. I had to step away and do something real quick.
Yeah, I've been leaning on my partner to do cooking.
Yeah, you kind of have to, right? I got y'all locked in front of a computer screen every single Monday, Tuesday, Wednesday nights at least, right? Nice dinners are for Thursday and Friday and Saturday, okay? Like, that's when y'all can have nice dinners. Otherwise, whatever y'all can get your hands on. I get it.
Whatever, Seth. I pre-cook on Sunday for Monday, Tuesday, and Wednesday so I can feed the people in my
There you
home.
go.
Hey, I hear you, Martha Stewart, but the rest of us don't necessarily plan that way. You know what I'm saying? So that's
I'm a buy the chicken at the store on my way home from work type of person.
Me too. Me too. Otherwise, if I buy too much, it all goes bad. I got to buy it to make that night, right? Like, that's what I do. Let me go back to that thought I was at, though, folks. Valid under basic contract law is a contract that contains all the elements, okay? Let's go off on a tangent here. What were the essential elements under basic contract law?
Agreement.
Mutual agreement.
Constitution. Consideration.
Consideration.
Contractual capacity.
Yeah, legal capacity to contract. 18, sane and sober. And what was the last one?
Loyalty.
Legality. It must be legal.
Legality, right? Legality. It's got to be for a legal act. A legal act, okay? For a legal purpose. So as long as it... Say again?
I will forever remember that gangster thing that you gave us an example, or that the meth something.
You know why? You know why I do that? Because of exactly what you just said, folks. Nobody is not paying attention when I throw crystal meth and murder into the lesson, right? Everybody, no matter what you're doing, you stop everything and like he said, what? Crystal, huh? Murder for what? You will remember that because it is such an abstract thing. I told you, there's a method to my madness. If you're entertained, you're listening. If you're listening, you're paying attention, or you're learning, right? It all comes full circle. So, there you go. So, a valid contract contains all the essential elements under basic contract law, those four things. One thing that's not required in general for contracts, as weird as it is for your brain to process this, is writing. Okay, writing. And so certain states have their own statute of frauds, which requires certain contracts to be in writing to be enforceable in a court of law. And so when we're dealing with these kind of different pieces, there's this weird overlap, right? You got to be very careful because of the way that this flows. So valid is containing all the essential elements, presumably enforceable, not guaranteed to be enforceable. And then we've got voidable. Okay, what does voidable mean?
It means that it can be void, but it doesn't have to be.
Right, yeah.
It means mine's a contract, drunk as a skunk, high as a kite. There's no good.
Let me combine that all together. Voidable means potentially one party has the right to get out of it. Okay, that's what voidable means. And so, you know, everything y'all said was true. But think of it that way. One party potentially has the right to get out of it, to render it void for all intents and purposes. And so the examples, as Stephanie just relayed to us, that you have to remember for voidable is a minor, okay? Somebody under the age of 18 signing a contract would be voidable, at least in the state of North Carolina. And then somebody being under the influence, drunk as a skunk, high as a kite. That would be temporarily out of sound mind. And so if you were to sign the contract at the time that you were temporarily out of sound mind, then you would that contract would be potentially voidable, right? A party has the right to get out of it. So then what does void mean?
It means that the contract's not valid.
Yeah,
Void means it's missing an element.
A lot of different things, right? It's missing an essential element would make it void. Same as having no contract at all. Unenforceable.
Yes, that's what I have. No contract at all.
It's the same as having no contract at all, but understand that it's multiple things, right? It's the same as having no contract, and because there's no contract, there's no enforceability. So void contracts are always unenforceable contracts, okay? So what was the most common examples? Stephanie gave one. Something for something missing an essential element would be void. What were the other examples we gave you?
Mental incompetence.
Somebody who has been declared mentally incompetent by a court of competent jurisdiction. That's how we articulate it. And that would have had to have happened before they entered into this contract. That would absolutely be a void one. And then the other one...
Britney Spears.
Yeah, Britney Spears was a prime example of that when she was in her conservatorship. Now, she's actually had her rights given back to her. As I said on day one, I don't know that that's necessarily was the best idea. But in the time that she was in her conservatorship, yeah, anything she signed would have been void. And so the other one that I throw into the mix, which is technically the same as the first one, is for an illegal act. Because if it's for an illegal act, it's missing an essential element. But that is a very common... example that they utilize for testing purposes, okay? That illegal act is very commonly utilized. So we also pointed out, and you got to be careful, that a void contract, while not technically a contract and not enforceable in a court of law in any way, shape, and form, folks, could be completed. An unenforceable contract under the statute of frauds could be completed. It's just that when I say it's unenforceable, if we don't do what we say we're going to do, then you can't take it to a court of law. And at that point, what was the point of having a contract? Because I told you, contracts really only mean one thing in a court of law. If there's no way to force somebody to do what they said you need to do, then why'd you even bother putting it into a contract? At that point, you should have just had a handshake, right? So then we got into, a few more details. We talked about an amendment versus an addendum, and that's where, yet again, I warned you from a national to state side, got to be careful. From a state point of view, an addendum, the plural of which is addenda, is an addition to an offer to be part of the initial contract formation. Now, we're going to be talking about contract formation in a few seconds. And then an amendment in North Carolina is a change to an already executory contract, a contract that is in place. All parties have agreed to it. It's going on, but we've decided to change it. And you can't make these changes unless, once again, mutual agreement comes into play, because there's multiple parties to this contract. Now, I told you for other states, maybe on a national, sometimes they'll use this verbiage a little more interchangeably, which is kind of one of these unfair things that does happen sometimes. So I would just say that if you get any, and you will get basic contract law questions on both, but if you get any questions on the amendment versus the addenda on the national, read it very, very carefully. And hopefully they won't be that mean to you. And so then we wrapped up with this concept right here, okay? A contingency. And I told you a contingency is basically a get-out-of-jail-free card for all intents and purposes, contractually speaking. It is something that you would put into an offer that when it's accepted, it's basically in the contract that you can escape with no penalties. Now, you don't necessarily understand in North Carolina specifics in the due diligence period yet. We're going to get into that. But understand that this is a national concept. A contingency could happen in any state. And they're not exceptionally common in any way, shape, and form. Because why would most people accept these when there's plenty of buyers who are willing to buy it without these? Doesn't mean that they don't get accepted, but you're going to be tested on what is it, right? I'm not going to do this if I can't do that, and I don't want to be punished for it. There are lots of types: contingent sale addendum, financing contingency, whatever we wanted to throw into a contract, it could potentially be a contingency. Now, there's no standard provision in North Carolina for this. If you wanted to add this in, an attorney would have to draft it. So that would lead us to the new stuff. Y'all ready? Whoop, whoop. Don't you shake your head, Stephanie. We're always ready for new stuff. Drinking from those 3 fire hoses simultaneously.
It don't matter if we're ready or not.
It's exactly right. You ain't got no choice. It's coming at you whether you like it or not. Okay? You might as well enjoy it. Jacob says drinking from 3 hoses is an understatement. Yeah, for sure. Kind of is. I mean, it's definitely more than one. We know that. So let me ask you a question we didn't get to last night as we move into some new stuff, okay? Here's the question. True or false, in order for a real estate sales contract to be enforceable, there must be an exchange of things of value between the two parties.
True.
True. Consideration is that thing of value. That is an essential element. If you're lacking an essential element, it would never be enforceable. So you would absolutely have to have consideration. Now, as we're talking about these essential elements, right? Mutual agreement, consideration, legally competent parties, and for a legal act. I told you, don't Google essential elements of a contract because it will hurt your feelings, because if you're, a law student, there's a little more detail versus real estate curriculum, which utilizes these four, and that's where we're going to stop. But let's dive deeper into one of them, the mutual agreement, okay? I told you yesterday that contracts are voluntary, and they will always be voluntary. You can't force anybody into a contract. Because if I looked at Dora and I said, Dora, I'll give you $20 for your house. That's not a contract. That's an offer, and it's a pitiful offer at that. Okay? So a contract is only formed when all parties are in complete and utter agreement and it meets all the other criteria simultaneously. Now, I warned you yesterday, there are a lot of names for this mutual agreement, this voluntary piece, okay? It is called mutual agreement, mutual assent, reality of consent, mutuality of consent. There's a lot of different verbiages they will use, but ultimately it just means we've agreed. And so in order for us to actually have agreed, there must be no items that are present that could contradict the fact that we agreed. So let me give you a couple examples here. If I offered to sell you a property that I had that had 200 acres, and after you contracted on it, come to find out that it was only 170 acres. Well, whether that was intentional, whether it was a mistake, it doesn't matter. Can we all agree that that changes what you thought you were getting? You thought you were getting 200 acres. You gave me a price based on 200 acres. So a mistake in the advertisement of what we're dealing with would be potentially voidable because it actually could arguably lack mutual agreement. Does that statement make sense? Hang tight, Kingsley, and I'll come back around and answer that chat after I finish this thought. The other ones are duress and undue influence. So yet again, if you were to put a gun to somebody's head and say, sign this contract or I will kill you, and they sign it, you've got a signed contract. It looks like we have agreement, but can we all agree that if you are threatening somebody with life or death or duress, then you could argue that there is no mutual assent and you could potentially be void. You could void that contract. It would be voidable by the person who was under duress because you could prove that it would lack mutual assent. And the last one goes kind of in the same vein. It's undue influence. So no physical threat of harm, but because of some type of control, it may be some type of emotional harm or stressful thing that somebody may, experience. And so let me give you an example. If you went to your parent who was elderly, who was living in their home, and you looked at him and you say, listen, if you don't sign this contract to sell your house, I'm going to put you in a nursing home and you will rot there. You didn't necessarily threaten to hurt them, but could that be undue influence that caused them to enter into that contract, not of their own volition? All of these things could potentially make a contract voidable because you could argue that it lacked this mutual agreement. I just clicked the link. Let me see if it pops up here because that's itty bitty, Kingsley. I can't read it over there in that chat box. The guardian for a mentally incompetent party enters into an oral contract with another party to buy a trade fixture. Yeah, I agree with Eliza. This is looking real B-ish to me. And I'll kind of tell you my thought process. Let me zoom in a little bit here. It's trying to trip you up with words. The guardian for a mentally incompetent party. Okay, well, that means the guardian is mentally competent, so they are of sound mind. Enters into an oral contract with another party to buy a trade fixture. Well, folks, what's a trade fixture?
Like a
Still,
For your job. For your business, excuse me.
There you go. We talked about it. It was also called what? What's the other name for a trade fixture?
Improvements, right?
That's a generic term. That's not the trade fixture.
Is it shuttle?
Chattel fixture. Chattel fixture. So a trade fixture is, you know, when you install your prep tables, your hair salon equipment, your things in a business that you're renting. It's personal property, and it remains personal property. So it's kind of contradictory, right? It says fixture, but it's not. It's personal property. So in other words, a mentally competent person entered into a contract to buy personal property. Well, personal property contracts are not outlined under the statute of frauds, which means that even though it is an oral agreement, it is potentially valid and enforceable. It's not about real property. And this person is of sound mind. Does that make sense? So you've got arguably all the essential elements. It's legal, there's consideration, legally competent parties, mutual agreement.
What is oral?
It's oral, and that's okay. Don't forget, not every contract has to be in writing. Only the ones named on the statute of frauds have to be in writing. So in the statute of frauds, we've got contracts for the sale of real property, promissory notes, restrictive covenants, leases in excess of 3 years. If it's not named on that list, it's absolutely enforceable in a court of law, even though it's not in writing. This is where a lot of people get tripped up because you think, oh, well, every contract has to be in writing. No, it doesn't. And you will get test questions. It'll say something like a lease for 2 years is an oral agreement, isn't enforceable in a court of law. Absolutely. Because it is for less than 3. Only leases in excess of 3 years have to be in writing to be enforceable in a court of law. That make sense?
Yep.
Yep. This is where this stuff, I know, there's all these different layers, right? All these different layers. And that's why I'm trying to caution you of these different, I know, Monica, just, That's why I'm trying to caution y'all about some of the biggest things that they'll try to trip you up on. And this is a perfect example of what I mean. They threw in unnecessary information. Guardian for mentally incompetent person. They're trying to trick you. Oh, mentally incompetent person. I know that that's void. Nope. They didn't enter into a contract. The guardian did. Got to be careful. So with this mutuality of assent, reality of consent, this agreement, whatever you want to call it, I told you, you cannot have any mistake, misrepresentation, or fraud, because all of that could potentially make it voidable because it lacks actual mutual assent or mutual agreement. Now, one other thing that comes into play here is what we call non-illusory, which it's trying to say is no illusions. What they mean there is anything that would suggest that there's actually something of value when there really isn't. And let me give you an example. How many of you follow cryptocurrency in any way, shape, and form? What is the exchange rate right now, Justin, on Shiba Inu?
Probably a penny. No, not even a penny.
Probably not even a penny, right?
It's a volatile market.
It is a volatile market. While Justin's looking that up, I'm just going to guess. I'm going to use Sandeep's guess at a penny. But here's the point that I'm trying to make, folks. If you are not very well versed in cryptocurrency, and I walked up to you, oh my God, 0.00001177. Yeah. So fractions of a penny. I mean, you would need a crap ton to even equal 1 penny. Here's the point, folks. If you were offering somebody to buy their house for 100 million Shiba Inu, that sounds like a lot. It's probably $7.25. Okay? That would be illusory. You're trying to trick somebody by making it sound like you're paying them oodles of money, and so that would also contain misrepresentation and be potentially voidable by the party who you're trying to trick under this mutuality of consent. Dang, that's pretty low. I didn't realize it was that low. 0.000117. If you got $10, you can be a billionaire in Shiba Inu, all right? That's how it works.
Seth, can you do me a favor and use non-illusory or Yeah, in a sentence. So like, it said be careful and watch out for it. How would that be used in a sentence?
It wouldn't necessarily be used in a sentence. It would be used in a context, right? Like promising to give somebody something that has zero value, or, you know, as I just gave you that example, trying to convince somebody that you're giving them a lot. 100 million Shiba Inu sounds like a lot. And so that would be illusory, okay? And so when we're dealing with contracts or misrepresentation, it has to be non-illusory. You cannot try to trick people into entering into a contract. That's all that's saying. Illusory is you're trying to give the illusion of more money. So non-illusory would be necessary. Otherwise, it could potentially be voidable because it lacks that mutual agreement again. That's it. You're not going to see, they're probably not going to use the term illusory on the test. If they were, it would just be, non-illusory would be, you know, with actual consideration. Illusory would mean tricking them into thinking there's consideration when there's not. So let's talk about the next really big, really testable piece of this, okay? I keep telling you that every single thing starts out as an offer and then could ultimately turn into a contract. And so let's talk about the flow of this for a second. If we were to offer somebody, let's just use real estate sales contracts. If we're to offer them, the question was asked yesterday, well, how do offers go? Are they verbal? Are they in writing? Well, because we deal with real estate and our statute of frauds requires all of our contracts to be in writing, all of our offers are also in writing. So I want you to think of an offer as something that can be accepted. So let me tell you how an offer actually works. We would have a document and we would write up all the terms on it. Like, okay, well, I'd like to buy your house for $400,000. We're going to close on April 2nd. We want you to pay, $3,000 of our closing cost. And there's a lot more details on there, but here's, just some in a nutshell. So what happens is, remember we talked about these ors and es. An offer always starts with the offer or and goes to the offer e. So or is the give or, e is the receivee. Corey, explain to me what you mean so I can answer correctly. I think I know what you mean, but I just want to make sure so I can confirm. Oh, sorry, you're muted, Corey. The question is, can this be expanded to copy? So tell me what you mean. Nope. Oh, hold on. Your microphone's doing something crazy. You're like muting, unmuting, muting, unmuting. Try one more time. There you go.
Okay. Can it be expanded to make bigger on the screen, though?
Oh, can I expand this to be bigger on the screen?
Yeah.
I cannot, but I could share the visual with you in another format later that's bigger if you want it.
That'll work perfectly.
Okay, yeah, I apologize. I didn't understand what you meant. Yeah, this is just slapped into a slide, and because the slide is, only so big, I can't make it any bigger. But we're going to talk more about it, so this is just a visual, and I can give you a copy of it later. So,
Right, sweet.
Yep, no problem. So here's the deal. If we are dealing with an offer, okay, because we deal with real estate and our statute of frauds says so, all of these have to be in writing. So the offer or, which typically is the buyer, but please do not ever think of the offer or as the buyer. It is just the person who sends the offer. And then the receivee, right, is the offeree. So here's what happens. This offer gets drafted up. And then the offer or would actually sign and date this offer. And so what they're doing when they do that is they're saying, here's my offer. I like it, and I hope that you like it as well to the extent that you just accept it. And so when you send that offer over, it goes from the offer or to the offer e. And the offeree can look at this offer and they can review it. And there is a line for them to sign as well. If they want to, they can accept it. And they accept it by signing it and dating it and making no changes. Now, let me tell you, and we're going to get there, but I'm going to go ahead and tell you one of the most critically important and testable pieces of what we'll call contract formation. Let me use some names here, okay? I'm the offeror, and I just sent this offer to Monica, who is the offeree. Monica signed it with no changes. Folks, if, let's say, under different circumstances where we're not sitting in the same Zoom room, Monica is at her house, I'm at my house, Monica signs my offer with no changes, do I know that Monica signed my offer?
No,
No.
No.
not until you physically see it or you're told that it's signed.
There you go, folks. Signature is what we call indicative of acceptance, but it's not enough to actually form a contract. The most critical piece of contract formation, moving from an offer to a contract, is communication of the acceptance. You have to inform somebody. And here's a very powerful statement. It is always communication of acceptance to the offeror or the offeror's agent. So Monica would have to tell me that she signed it, and that second that I've been told we're under contract. That is so important.
Constructive knowledge, is that what that's?
Say again?
Constructive knowledge?
Well, constructive, we typically, it's basically what it is, but we use that terminology more, the register of deeds. When you record the deed, it is a constructive notice to the public. This is just essential under contract formation laws. You do not have a contract unless it has been communicated. Now, we're going to talk more about this in a second. So that is the general flow. You send an offer. If they like it, they would sign and date it with no changes, and they communicate that acceptance back. Okay? Well, I'll just use the same people as the example. Let me kind of erase this, though. I send this offer to Monica, and Monica doesn't like it. And so she just says, go to hell. It's called a rejection. She says, no, thank you. She has rejected my offer. Now, folks, here's the thing. I want you to think of offers as a living, breathing thing. Better yet, the way that I like to teach it, because otherwise it gets dark really quick with the examples I'm about to give you, think of them as flowers, okay? Think of them as flowers. So this offer that I want you to think of as flowers, I give these flowers to Monica. She throws them on the ground and she stomps on them. Can she bring them back to life? No.
Possibly.
No. No.
Why not? Add a little water or something. The little
She stomped on them, Dora.
You squish them? No.
She stomped. Also, Dora, just go along with my analogies, otherwise you're screwing yourself on the test. This is not a biology class. We don't want Frankenstein flowers. Listen, she put them in the shredder. Does that make you feel better? She set them on fire. Feel better now? Okay. She set them on fire. Can she bring those flowers back to life? No. And you've got to think of offers exactly like these flowers. When you have murdered these flowers, you cannot bring them back to life. So I want you to understand that, folks. If I send this offer to Monica and Monica says no, she cannot change her mind later and say, oh, I've changed my mind, I'm going to accept it. It's dead. She's killed it. That is very important. Now, she could send an offer to me with the exact same terms. She could call me up and ask me if the offer was still on the table and ask me to send it again. But if that doesn't happen, it is what it is. She has killed it. It is dead. Now, the other thing that could happen, and we've talked a little bit about this, some people had questions throughout the course. Instead of just outright rejecting it, she says, well, Seth, I like everything, but I'm not going to pay $3,000 in closing costs. I'll only pay $2,000. So this is what a counteroffer is. And I want you to, for the sake of the test, you have to think of a counteroffer as something that can be accepted. So let me show you what a counteroffer looks like. She signs and dates my offer, but she also puts a strike through on the closing costs I asked for. She changes it to $2,000. And she initials and dates that change. So this is a counteroffer. Really and truthfully, what it is still a rejection, right? She has rejected my offer as I wrote it, but she has created a new offer and she has sent it back to me. Now, here's a very important thing to understand. My offer, as it was sent, is still dead. She cannot go back and re-accept it because she killed it. It was a rejection. But more than that, our roles have switched. I started off as presumably the buyer and the offeror. But when she rejected my offer, she changed our roles when she created a new one. Now, Monica down here is the offeror, and when she sent this to me, I am now the offeree, which is why you can never think of offeror and offeree as buyer or seller specifically. It could be either or depending on the context. Now, folks,
I have a question.
let me say my last statement, then I'll let you ask it.
Okay.
We're not under contract because I sent something to her and I said, I like this, I hope you do. She said, nope, I don't like that, but I like this, I hope you do. Now what has to happen before we could be under contract in this scenario?
You have to sign it again saying that you agree to the 2,000 in closing costs over the 3,000 in closing.
So I would have to initial and date that myself, saying that I'm okay with that. And then what would have to happen?
Then you would have to send it back to Monica so that or let Monica know.
There you go.
Communicate with Monica.
Communicate it back to Monica that I have accepted that counteroffer. That's exactly right.
You just answered my question, so you don't have to worry about it.
There you go. That's kind of what I was thinking, because you always have good questions, but I'm always like 30 seconds away from like getting right there to that point. That's great. That's great. That means you're thinking about it. Now, I'm going to give you a couple scenarios here. We're going to talk about this in more detail, but does this kind of make some sense, folks? You got to understand, this is all part of that mutual agreement piece. We send an offer, and we've got to wait for you to voluntarily accept it, and then let us know. That's how we get this mutual agreement, this meeting of the minds coming together on this. What you got, Justin?
So if you can refresh my memory, with the closing costs, where does that go? Who does that go to?
It goes to the buyer. So that was just an example. That was a request. It's just a negotiation where I requested for Monica to pay some of my closing costs. It's called, seller paid closing costs. So it would go to me as the buyer as a credit at closing. Remember, those credits and debits. It would be a debit from Monica and a credit to me. And it just helps pay some of my closing costs. No. So the reason this is really important is because they're going to give you a plethora of scenarios where you are going to be asked, do we have a contract yet? And you're going to have to kind of follow the chain of events here. Now, we're going to expand on this. That was just your introduction to it. So an offer is just an offer. And it will never become a contract until it is signed with no changes and communicated back to the offeror or the offeror's agent. At that point, we have a contract. Now, folks, let me tell you why this is important from a real-world point of view. It's extremely testable, but let me just really paint a picture for you as to why this is important for your career. Folks, in North Carolina, we often utilize a due diligence style contract, and we negotiate both due diligence and or earnest money, depending. And we have seen some astronomically large amounts of due diligence over the past couple years. I had a sale a few years ago where somebody offered my client $50,000 in due diligence money. Due diligence money is non-refundable. If you back out for any reason or no reason, you lose it. And I want you to understand something. The second it becomes a contract, the buyer owes the seller the due diligence money. No ifs, ands, buts, or coconuts. So if you don't understand when a contract is formed and you advise your client poorly, you could be the difference between your client losing or not $50,000 plus. This is extremely important in the real world, as well as the test.
So question, would someone offer something that high to let the seller know that they're they're very committed to owning, or right? They're serious about this offer.
Yeah, serious and stupid. But yeah, serious.
I have a question
Seth-
too.
Go ahead, Sam.
Was that due diligence offered before the like an inspection of the house?
Oh, yeah. Inspections don't happen till after, which means no matter what was on that inspection, they were buying that damn house, weren't they? Because there ain't nothing they probably could have found that would have been worth walking away and losing. Listen, as the listing agent and as my sellers, we were like, please walk away. Please walk away. Because then we'll just put it right back on the market and we'll get another chunk of change.
Yeah.
They didn't walk away.
Seth, so that 50,000 wouldn't be credited in closing to the seller's purchase price?
It would if they closed on it. I said they'd lose it if they backed out.
Okay. All right.
Yeah, it stays your money if you close.
Due diligence.
Say what?
I've never dealt with due diligence.
Yeah, we're going to talk about it in great detail tonight. Yeah.
I hope so.
Oh, yes.
Oh, yeah.
He was talking about was not due diligence, though. He's talking about closing costs.
No. I was just, the $50,000 was due diligence.
Oh, I thought you were saying that you were talking about closing costs still.
Ernest, don't get Ernest.
No, yeah. Where have some of y'all been the past 30 seconds? I don't know what's going on anymore. I was quite literally talking about due diligence money. And I mean, I talked about a lot of different concepts, but in that moment, we were just talking about due diligence money. But Missy's question was, as long as you go to closing, do you keep that money? Yes, of course. It's not just money on top of. It does get credited back to the buyer if they buy the house. But if they walk away from the house, they forfeit that money.
So Seth, just in my experiences of what I've seen, a lot of people from up north give higher due diligence because when they sell their property up north, their properties are worth a lot more. So they offer a higher due diligence so that they can be guaranteed to get the property or have a better guarantee to get a property.
Yeah, and what you're talking about is just statistics, right? Statistically speaking, people coming from up north made more money on the sale than people who sold from down the road. But at the end of the day, it all comes down to how much money are you comfortable with potentially losing and how serious are you about the property. Now, just understand, I'm not going to teach you what's good or bad, in regard to offering due diligence. I would say that it's very ill-advised to offer that high of an amount unless you are just rolling in the dough, don't care about the repercussions or otherwise. I mean, because there's a lot of things that could arise. And remember, North Carolina is a doctrine of caveat emptor state. There's a big danger there because there could be some severe issues with that property. What you got, Jacob?
Okay, so the upfront cash that we're talking about, the due diligence, right? I was always under the impression that is given before closing, that's not a credit, that's something that is given to them beforehand.
It is. It is given to them as part of the initial contract formation. The buyer gives it to the seller, the due diligence money. But then the seller credits it back to the buyer at closing because it is the buyer's money if they go to closing.
Copy. Okay, that makes sense.
Yeah. And we're going to get there, folks. I know this due diligence thing is very fascinating. I was just giving an example of why the contracts are so important. Rest assured, we will talk about due diligence in just a moment when we get into the actual North Carolina sales contracts later tonight. But right now, we're just talking about forming a contract, okay? Moving from an offer. Now, folks, let me explain why this is so important. Offers are very easy to kill. Contracts are not. Contracts have penalties when you don't do what you're supposed to do. Offers are just offers. Very different monster. So when we're dealing with contracts, okay, talking about formation of a contract, I told you, you can have an acceptance, and we're going to get more into that in a second. You could have a rejection or you could have a counteroffer. Now, the counteroffer is a rejection and switching the roles, right? The offeree now becomes the offeror and the offeror now becomes the offeree. Well, let me throw a couple other things into the mix here. When we're dealing with the communication, I told you that is critical, but it is always communication to the offeror and or the offeror's agent. That is exactly how you should always think about this communication. Communication is never going to be happening to the offeree or the offeree's agent. Because if the roles switch, right, it's always the offeror or the offeror's agent. Now, let me explain to you what I mean when I say the offeror's agent. If in that scenario where I gave an offer to Monica, and I was the buyer, she was the seller, Monica accepted my offer with no changes, and instead of communicating it back to me, she communicated it back to Stephanie, who was my buyer's agent. Stephanie knowing is enough to get me under contract. For this communication of acceptance, if your agent has been communicated with, you are under contract. We have this unique thing where your agent stands in your shoes for this communication of acceptance. And that's a weird and abstract thing that a lot of people don't like, because I want you to think about this. Monica emails Stephanie, my agent, to let her know that we're under contract. Stephanie's on vacation. She hasn't checked her email. And so 3 days later, 4 days later, 5 days later, Stephanie still hasn't told me. And I'm like, I need to know if I got this house or not. All the while, I've been under contract, but Stephanie never told me. Now, hold on that. We're going to talk about the communication piece. I'm probably going to answer your question. I'm just giving some examples to lead into what I'm about to talk about. Now, this last note before we talk about the communication piece more in depth. We have the delivery of instruments rule, which we've kind of alluded to in the earlier agency sections. In North Carolina, you have to deliver everything immediately, in no case later than 3 days. So an offer goes to a listing agent. They have to deliver it to the seller immediately, in no case later than 3 days. Well, we also have rules in regard to how we handle multiple offers when we're delivering them. Now, I'm going to go ahead and I'm going to make this very known. Folks, it is very common to, especially in this market, have multiple offers. It's slowed down a little bit, but over the past couple of years, we've had it. And so we have to deliver every single offer that comes in. And the way that we do these multiple offers in North Carolina is we deliver them all immediately in no particular order. Yes, we will ultimately advise our clients on which offer may be best for them. But remember, when we talked about agency and tiers of authority, what tier of authority do you have when you are working with buyers and sellers? It's in that. Hold on, say it again.
Could you ask that question again? Sorry.
Yeah, which specific tier of authority? You were in the right category, Monica, but which specific tier of authority do you have when you are an agent working for a buyer or a seller?
Wasn't it special?
Special. Yeah, special. So special agency, remember, you are an advisor. You are not binding them to anything. You're not making decisions for them. And so if you were to deliver offers where you said, here's the best one, what did you just do? What did you just do? If you just handed them the offer and said, here's the best offer, what did you just do?
Advice. You made a decision.
You made a decision. You can't make that decision. So we do not deliver them and say, here's the best one, here's the second best one, here's the third, because that's us making decisions for them. We have to deliver all of them immediately in no particular order. Yes, once they get them all, we will have discussions with them on which one may be best for their needs after explaining them. But you have to understand, on the test for North Carolina, you're not going to ever pick the best one for them and just deliver that one. Deliver all of them immediately, in no case later than 3 days, in no particular order. Yes, ultimately we will help advise them on which one to pick, but that doesn't come into play during the delivery process. Everybody okay with that statement?
So you said immediately and no more than 3 days.
Yep, that is a very specific North Carolina rule. So that is North Carolina.
What do I select? Do I select immediately or do I select no more than 3 days?
They will not have those two answers on the same test question. The rule is you have to deliver them immediately, but in no case later than 3 days. So as long as you deliver it within 3 days, you're legally okay. So let's talk about the communication. I keep talking about that this communication is a very critically important piece, and I mean it. You cannot form a contract if you don't have communication. And it is always, as I said, communication of acceptance to the offeror or the offeror's agent. Well, let's talk about the different ways that this communication can happen. There are a lot of them. Yet again, this is something that you may be like, well, I don't like that. It doesn't make sense. I don't care. This is how it's tested. That communication, folks, can be just about any way that you could fathom. We could call you and tell you. We could tell you face to face. We could email you. We could text you. We could leave a voicemail. We could probably use a freaking carrier pigeon. We could probably use smoke signals. We could fax it to you. Folks, just about every way you could possibly fathom to communicate with somebody would be considered communication. It would. Now, one of the reasons why electronic communications are acceptable is because what a time to be alive in 2024. A while back, there was a piece of legislation passed called the UETA, the Uniform Electronic Transactions Act, which basically dictated that a digital signature is just as legally binding as a wet signature, and that digital communications are acceptable as face-to-face communications, which is why we can text, which is why we can email, which is why we can use programs like DocuSign, DigiSign, all these different pieces. What you got, Jacob?
Okay, so I want to ask a hypothetical question.
Don't go too rabbit hole-y on me, Jacob.
I don't think it's that rabbit hole. I think
We'll see.
So we're talking about accepting, accepting offers,
Yep.
everything like that, right? So say I have a client or not a client, right? So me and my seller are accepting an offer from the offerer, the buyer, and say we send the. Wait, no, never mind. I'm confusing myself. I'm sorry. I've had a long day.
Yeah, that's all right. Yeah, maybe.
Everything I just said.
Okay. All right. Folks, let me throw one into the mix that really just drives us all bonkers, okay? There is this very antiquated rule that's still alive and well. And it is called the mailbox rule. And you're not going to like it, but it is still on your test, okay? Once upon a time...
The mailbox rule.
Say what?
I'm sorry. Oops, I hate the mailbox rule.
Oh, I thought you were telling me that. You were just saying it to yourself and just happened to be unmuted. It's okay. It's okay. Everybody hates it. Everybody hates it, Monica. It's okay. The mailbox rule is this old school rule because you have to understand that we have not been as technologically advanced as we are now always. And so mail used to be a very commonplace form of communication. And so it is the same premise as if you've ever seen, if this is before your time, some of you have been alive during this time, but some of you have not. If you've never seen or heard that, like tax season is upon us. Well, as long as your tax return was postmarked by April 15th, you were considered to have delivered them on time. And so the post office used to stay open until midnight on April 15th. That was a thing. And so it's the same basic concept. So let me explain this. The mailbox rule states that if you were to mail communication of acceptance directly to the offeror or the offeror's agent, even though they haven't received it yet, it is considered a contract the second that it is in the possession of the United States Postal Service. There's no possible way for the offeror or the offeror's agent to know that, but it's still considered legally communicated as soon as it is in the possession of the United States Postal Service. So if you were to put it in your mailbox, now don't go, too specific on this. I'm not trying to trick you in any way, shape, or form. I would argue that, like once the mailman picks it up, it's out of your possession, it's communicated. If you take it to the post office and put it in the mailbox that you can't get it back, it's communicated. The second it's in the possession of the United States Postal Service, you're in a contract if it was sent to the appropriate party. What you got, Jacob?
Okay, I unconfused my question.
We'll see.
No, I did. I unconfused it.
Okay.
So Seth, say I'm selling, you're buying. Okay. You send me an offer. I send you a counter offer. Okay. So I'm waiting on you to either accept it to put us under contract, right? Let's say then, while I'm waiting for that, Monica comes in and gives me an even better offer, and I want that offer. Can I accept that offer even though I've already given you an offer?
Yes, hang tight. The thing is, offers are living, breathing things for all intents and purposes. So understand that if you were to accept Monica's offer exactly as written, I don't know that, so the one that I have in my hand is still alive and well. So let's piece this together, Jacob. What happens if I sign that counteroffer you sent me and communicate that acceptance back to you after you sign Monica's and communicate it to her? What does that mean for you?
Then I'm under contract with two people.
And then you're under contract with two people, and that's a problem.
So, yeah, so what do you do?
We're going to talk about killing offers in just a moment. You can kill an offer. Offers are easy to kill. You can basically say it's off the table. Hang tight. Kirsten says, does anybody still use this method? No. They shouldn't, but is it still testable? Yes. Understand too, folks, the mailbox rule applies to communication of acceptance only. I'm going to say that again. The mailbox rule applies to communication of acceptance only. It does not apply to a rejection. It does not apply to a negotiation. It does not apply to anything else. So if you are signing something with no changes and communicating it back, the mailbox rule comes into play. Now, folks, I want you to understand some of these things. You do not have to have listened to the voicemail. You do not have to have seen the email. If it has been sent to you, it's under contract, whether you've synced it or not. So let's build the layer on this. When you're dealing with these offers, I told you, should be thought of as living, breathing things that can be accepted. Well, because of the dangers, as Jacob just asked about different things that could arise, folks, it's very important to understand that sometimes we have to kill those offers. Now, I've already given you a couple ways those offers die. One of them is a rejection, another one's a counteroffer, because a counteroffer is a rejection and we've switched the roles. But there are other ways that we can kill an offer. Now, I want you to understand that an offer can be revoked anytime prior to unconditional acceptance. So let's go back to that scenario where Jacob sent me a counteroffer and Monica's offer came in and he likes Out and Better. All he has to do is communicate to me. I take my offer back. It's no longer on the table. It's dead. It's that simple. He just has to state it's not valid anymore. It's not on the table. I revoke my offer. And it can be something as simple as an email. Hey, Seth, remember that counteroffer I sent you? I revoke it. I'm taking a different offer. He's killed it. That's all it takes. So you can revoke it as the offer or anytime prior to unconditional acceptance is the verbiage we like to use. Anytime prior to unconditional acceptance. Meaning is that if it hasn't turned into a contract, you can take it back.
So if, and this is a little bit more rabbit holey, but say that they left me a voicemail or they gave my realtor left them a voicemail and they're on vacation. They haven't seen it yet, so nobody knows about it. And so we think that we haven't heard from him yet, and we accepted another offer and then tell them that our offer is not, on the table anymore or whatever. At this point, we are accidentally under contract with two people.
Correct.
At that point, what do you do? I mean, I'm assuming there's some sort of penalty for whichever one you back out of.
Yeah, you've got two contracts, legally speaking, under basic contract law, which means you are going to breach one and not breach the other, and you'll be subject to the penalties of the one you breach. Talk about penalties later. There you go. So you can revoke an offer as the offeror. Kirsten, why do you have that look on your face? Which part, Kirsten?
The whole thing.
Well, that doesn't help me narrow it down for you.
I think that example just like confused me, so I'm just gonna forget it for now.
Okay. I mean, it was a pretty advanced example, so let's take some baby steps first, and then we'll get there. So, how about this?
Why, thank you, Seth.
Well, it was a good one. We just hadn't quite gotten there. So, I sent an offer to Kirsten. That offer is this living, breathing thing that like flowers. If Kirsten says, give me some time to think about it, and over the next couple of days she's thinking about it, and I say, oh, I've changed my mind, I can send Kirsten an email and says, nope, not on the table anymore, I've changed my mind. It's dead. Kirsten cannot accept it anymore. So that is revocation of the offer by the offeror. I've killed it. Okay, well, let's backtrack. I sent her this offer. Kirsten rejects it. She's killed it. Okay, rejection by the offeree. Kirsten says, nope, I don't like this offer, but if you give me $305,000 instead of $300,000, that's a counter offer, and sends it back. She has still killed my offer, but now hers is alive and well, and the roles have changed. Now she's the or, I'm the E for this one, but this one is dead. Everybody okay with that statement? So the other more unique ways that are offers, let me say offers, because you have to keep them separate. Offers and contracts are not the same. One is a precursor to the other. So the other ways that they can die, one of them is lapse of time. Well, there's two different things that I need to bring into play here, okay? Lapse of time could be two different things. We can set a time limit on there. Basically, that Mission Impossible self-destruct sequence again. So we can say, if I send the offer to Kirsten, I could say, Kirsten, you got exactly 3 days to respond to this. And if you have not responded in 3 days, then it's dead. So day 3 rolls around. She hasn't responded. It's dead. Okay? It is what we call an expiration of offer. You can set a time limit that says, if you have not responded by this date and time, this offer is dead. And she cannot turn around and accept it. Everybody okay with that one? Okay. Well, the other one that comes into play for the lapse of time is basically what we would call within a reasonable period of time. Now let's play a fun game, folks. Do me a favor. Go over to the chat and tell me what is a reasonable period of time to respond to an offer. A week, 3 days,
I would think
7 days. Say it again. How long? 3 days?
Yeah.
3 days, 3 days, 7 days, 24 to 72 hours. Seven days, 24 hours. Here's the thing, folks. The answer is who the hell knows. And I'm being completely honest with you. There is no actual time frame associated with this under basic contract law. So it does say that if you fail to respond in a reasonable period of time, but let me help you out here. What if I gave an offer to Kirsten and it has been 7 days and I've not heard anything from Kirsten, okay? I've waited 7 days and I said, well, geez, I guess she's just not taking my offer. So I go and I find another house I like and I put an offer in on that house. And it's Sam's house, okay? So I send this offer to Sam. Sam signs it, communicates acceptance. I'm now under contract with Sam. In 3 days after this time period has elapsed, Kirsten turns around, signs my offer with no changes, and sends it back to me. Here's the problem. I'm going to say to Kirsten, it's been 10 days. That ain't a reasonable period of time to respond. And Kirsten's going to say, it absolutely is a reasonable period of time. I had to think about it. You know who gets to decide who's right and who's wrong? Judge Judy. So if you've moved on from a property, what should you do?
Send a letter of revocation.
There you go. Revoke the offer. That's it.
Revocation of some form.
When I'm moving on, I should have sent an email to Kirsten saying, hey, Kirsten, I'm moving on. Never got a response from you. My offer's dead. This is dead now, so now there's no risk of me getting under contract a second time. I've killed it. It's dead. What you got, Sam?
Is Kirsten legally, like, would it be okay for Kirsten to just never say anything to you, or is she legally...
There's no legal obligation to respond.
She has no obligation to respond
Nope.
ever?
Nope.
Okay.
Nope. There is no obligation for an agent to respond if their client doesn't tell them to. There's no obligation for a seller or buyer to respond to an offer or counteroffer. Now, is it a bad practice? Is it, not necessarily good business etiquette? Sure, but it's not illegal to not respond. Yeah.
So you're within your right to, like, move on to Sam's house?
Sure, yeah.
Because yeah.
Yeah. Folks, let me tell you another big testable thing that just made me think of it after Sam's question here, okay? I told you we could put an expiration of offer. Let me ask you a question. Let's say in that scenario, I sent that offer to Kirsten, and I gave her 3 days to respond to my offer. How long do you think I have to wait before I can revoke my offer?
7 days or 10. Oh, sorry.
I think you would still be able to revoke it whenever you want to.
That one. Folks, don't ever forget that this exists. You can always revoke your offer as the offeror any time prior to unconditional acceptance. So in that scenario, I send an offer to Kirsten and I give her 3 days to respond. An hour later, I find Sam's house and I like it better. I can still revoke that offer 1 hour into that 3-day period. They will try to get you with this on the test. You do not have to actually wait 3 days to revoke it. It's just saying if nobody does anything and that third day comes, it self-destructs. It's dead on its own.
Just like an expiration date.
That's exactly it.
I'll give you 3 days to think about it.
That's right. There's no guaranteed 3 days. It will automatically go bad when that time is up. That being said, I'll let you take a break, mull this over, and I'll give you the last couple here. Come back at 7:20. I'll give it till 7:27. So we are talking about offers currently. Offers are that first stage that could potentially, under the right circumstances, move into a contract. And so right now we're talking about different ways that you can kill an offer. Now, I got a couple things I want to say before we talk about the last few. There are basically 3 categories of, documents to be killed that you have to keep straight in your mind. We've already talked about how agency contracts die. Right now, we're not talking about contracts at all. We're talking about offers, which is its own category, and you have to know how they die. And then there are sales contracts, which is the after the fact from this offer, and those die separately. So you've got to be able to keep these straight. So the next one's on the list, destruction of the subject matter. Well, these, unlike agency contracts, would kill it on either party's behalf. So if I, in that example I used earlier, put an offer in on Kirsten's house, and Kirsten's house, caught on fire or burned to the ground or whatever, the property was destroyed, that would kill my offer. Okay? Destruction of the property would kill the offer. Now, of course, other things could kill the offer as well, like that operation of law piece. If in the midst of the offer, the government said that they're going to take it by eminent domain, that would kill the offer. The same kind of things we talked about with the listing agreement, right? If bankruptcy protection prevented from selling it, if, it was foreclosed upon, all those could kill the offer. But the other piece that I want to get into is death of the parties yet again. Just like agency contracts, death of the parties does kill an offer. So Seth puts an offer in to Kirsten to buy Kirsten's home. Seth dies, the offer is dead. Seth puts an offer in to Kirsten to buy Kirsten's home. Kirsten dies, the offer is dead. Everybody okay with that statement? Death of the parties does kill an offer. But I will reiterate once again, death of the parties will not kill a sales contract. So while it's in this offer stage, death would kill it. But let's say that I sent an offer to Kirsten. Kirsten accepted it and communicated it back. Now it's no longer an offer, it's a contract. And if I die, the contract is still alive. If Kirsten dies, the contract is still alive. Sales contracts survive death. Agency contracts and offers do not. Now, the last one on this list, not too crazy. It's called supervening illegality. Basically, if something manifests or arises that would now make that offer illegal, it would kill the offer as well. You're not really going to be tested on supervening illegality. But yeah, that's all it is. If in the midst of the offer, something about that offer is now illegal, it kills the offer. Very rare for something like that to arise, but... So let me see how you're feeling with everything that I've thrown at you thus far, okay? I got a scenario for you to kind of look through, analyze. Take a minute and tell me what you think, okay? It's kind of long. And I'm not going to read it to you, so that way everybody can read it at their own pace, and you just kind of work through it and then tell me what you got. So here it is.
There's no offer. No.
No.
It was counter offered back again. So there's
Yeah.
That's what I say. He's still in the counter offer stages.
Yeah, let's just make sure we're all comfortable with everything that happens here, okay? On Sunday, an agent receives a written offer from the buyer. Now, folks, let me tell you how to think about these, okay? It's really useful, just like some of the other concepts, to draw a picture. Because we've got the OR side and the E side. So an agent receives a written offer from a buyer. So it came from the buyer to this agent over here on the E side for $145,000. That he has listed for $154,900. On Monday, the seller has countered at $149,900. Okay, well, what just happened? That means that's dead because that's a counter offer. Counter is a rejection, and so now the rules have changed. And now we got the OR on this side, the E on this side, and so here's that offer of $149,900. Gives the buyers 3 days to accept. On Wednesday, the buyers reject the counter offer. And upon being informed, the seller says he will accept the buyer's original offer. Well, they've killed this counter offer. The initial one was killed. There is no offer to accept anymore. Even though they want to accept it, they have murdered it. That offer would have to be made again, and so there is no contract. Everybody okay with that statement? There's nothing to accept. You can't go back and accept the original. I told you that. When you've killed it, right? Those flowers we set on fire, right, Dora? Those flowers were burned up. You can't bring them back to life. So there is no contract here.
Although I think Miracle Grow will revive them back.
No, they won't. Okay? There ain't nothing that strong. You burn the flowers. Absolutely not. Now, I didn't even give you any answer choices, right? But of course, if I had, you still would have gotten it because that would have made your life easier. But I wanted you to make you actually think here. Folks, tell you what I'm going to do. Just because there are so many contract questions, I'm going to give you an activity really quick. Let me see if I can find it. And it's giving you some scenarios. I'm not going to make you do all of them, but I'm going to make you do some of them. And I'm going to, because I think this is important, I'm going to give you some, I think this is the first time. We haven't done breakout rooms yet, have we? I don't think so. There are certain activities that I find worth our time. Of course, we've got to move very fast in this class because there's so much information, but this is one that I would consider worth our time. Let me see if I can find it here. Now, I'll be honest with you. This is an activity that I very often utilize in post-licensing as well because it's an important and very detailed activity, both for pre-licensing for your tests and, in the real world. And so if you end up taking post-licensing with me, you will have seen this activity once before. Oops, where did it go? Cool. So let me put this in the chat for you. It's just a Google Drive link, so it should open right up for you. Share. Here you go. It's called Do We Have a Contract? And as I said, you're going to notice that it says 302 on there because I do use it in a post-licensing course as well. But here's what I'm asking of you, okay? I don't want you to do all of them because we don't have time for that, but I want to make sure you're feeling comfortable. So here's what it looks like. There are a couple different scenarios, and you've got to decide if a contract has been formed or not based on the information that I've just taught you. I will give you one note because I sometimes will use these for like different quizzes and stuff, so I'll change the names around. On this one, I messed it up. It's got Susan, and then at one point there is Beth. They're the same person. You can just call her Susan Beth or whatever you want to call her. My mistake. But I just want you to, I'm going to put you in breakout rooms with like 2 to 3 or 2 to 4 people in each group. And I want you to have some discussions about the first 5. We'll just say the first 5 and we should be okay. And then I'll give honorable mention to one of them. So if some of your groups work faster than others, I want you to do the first 5 and number 8. Okay, the first 5 and number 8. So get it open, and I'm gonna open up what's called a breakout room. A breakout room is where you're in your own little Zoom room. And so it's just going to be your group, so you can unmute and talk with much smaller groups of people. I'm going to jump through. That way you can actually have discussions about this. If we were all discussing it in this room, it'd be a hot mess express. 3 or so people, it's easy to have those discussions. So, all right. Welcome back, folks. I hope you all had a blast and a half in there doing your little breakout room, trying to discuss these things. It is important to understand when a contract is formed, and so I asked you to do the first 5, number 8 if you had time. So those are the ones I'm going to go over, and then I'm going to provide one more insight into a very specific concept here. But hopefully this will shed some light on this contract formation piece, okay? So, scenario 1, Todd buyer makes an offer to purchase on a property through his agent. His agent delivers it to the listing agent, who promptly delivers it to the seller. The seller is excited about the offer and wants to accept it. He signs the offer, places a copy in the mail to his agent, and calls his agent to communicate his acceptance. His agent congratulates him for selling the property. Do we have a contract?
Yes.
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 Folks, let's play a fun game. You ready for this?
Yeah.
Every single time, it's probably best for you to have a visual at this point in your lives. So let's have an or side. Let's have an e side, okay? Because it's always starts at the offer or and has to end at the offer or. Communication to the offer or the offeror's agent. So Todd buyer makes an offer to purchase a property through his agent. His agent delivers it to the listing agent. So went from the or side to the e side. We got this offer. The seller is excited about the offer and wants to accept it. So he signs that offer, which is one piece of the puzzle, and places a copy in the mail to his agent, still on this side, and calls his agent, still on this side, to communicate his acceptance. Did it ever make it back to the offeror or the offeror's agent?
No.
No, and it is always communication to the offeror or the offeror's agent. It has to go back to where it started. He only communicated with his person. It has to break that plane.
That definitely sounds like he's sending it to the other person's agent by saying his. I got beef with that question.
No, quite literally, that's a possessive. His. If I said our friend Jacob, his mama, does that sound like I'm talking about Monica's mama? His mama, his agent. That makes sense for everybody. You see how that works?
We didn't catch that part, though.
I know, which is why I made you do this exercise. I'm trying to train your brains as to what you can see on this test. It's not because I'm mean and hateful. I know it feels like it, but it's actually because I'm looking after you. I'm trying to prevent you from getting tricked on the test. Now's the time to be tricked, not the exam, right? Trying to train your brains. Dora, do you have a question?
Stephanie did catch that.
How, can you help me understand, how were you able to tell the EE and the OR?
Because the offeror is the giver of the offer. The buyer made that offer to the seller. Or is give or E is receivee. When you sent it, you were the or. The person who received it is the E. So it's whoever sent it. Now, if it was a counter offer, then the roles switch, because then the seller would be the or and the buyer would be the E. But it's where it starts is the or and where it goes, right? Who receives the offer is the E. Does that make sense?
So Todd the buyer, he's the OR, right?
The or, the offer or, because he is the give or of the offer. It is his offer.
Okay, thank you.
Misty, you said y'all caught it? Oh, you didn't catch it?
Oh, not y'all. Stephanie caught it.
Stephanie caught it.
Yeah, we got an offer. Stephanie's all like, wait, he mailed it to his agent. I was just like, yeah, I'm glad she's on my team.
It's all right. That's why we go back. It won't help you on the test, but that's why this is a learning activity, right? To help y'all understand these concepts. So everybody good with number 1 before we move on?
Yeah.
Okay. Number 2, Susan is a listing agent and leaves her seller's house late on Friday night with an accepted offer just signed by the seller. Knowing it is too late to contact the buyer's agent, she decides to simply fax the accepted offer to the real estate company of the buyer's agent in the morning. The next morning, before Susan is her name, okay, I told you, it's the same person, goes to her office to fax the offer. The buyer's agent calls Susan and notifies her that her buyer is revoking their offer because they have found another house. Can this buyer revoke their offer?
Yes.
Can. You are not under any contract.
Yes, he can.
For sure.
They can revoke their offer, but you're not under a contract.
Well, and that's the point, right? They can revoke their offer because no contract is formed. If it turns into a contract, then the answer is very different. So it was an offer that was signed by the offeree, but prior to notifying them of that acceptance, communicating that acceptance to turn it into a contract, the offeror's agent called to revoke it. And remember, the offeror can revoke any time prior to unconditional acceptance. Folks, what should Susan have done to protect her client?
She should have faxed it as soon as she got the acceptance.
Yeah, or better yet, emailed it. Because listen, the nearest fax machine, as I said yesterday, is in 1996. Okay, and I don't know about y'all, but I'm not going back there. So she should have emailed it, and it should have. Yeah, what was it like? Yeah, I can tell you all about it, Jacob. It was a glorious time, actually. The 90s were the best.
They sure were.
They were simpler time back then. So this. If she would have just emailed it, folks, it would have been a contract. Everybody understand that? If she would have just emailed it right then and there, because I told you, communicating it is enough. They don't even have to have seen it yet. Even if they would have emailed it at 2 o'clock in the morning while everybody's sleeping, you're under contract at 2 o'clock in the morning. Emails, text messages, voicemails, they all have a timestamp.
Okay.
Yeah, that makes sense?
On the acceptance.
On the acceptance. Yes. So, number 3, Luke Byers made an offer on a tract of land in Leland. He has not received a response from the seller in a few days and decides to pursue another piece of land in the area. He writes withdrawn on a copy of the offer, initials and dates the form, and places it in the mail directly to his agent. The next day, the seller decides to accept the offer. He signs it and places a copy in the mail directly to the buyer. Do we have a contract?
Yes, because his agent. I got that one wrong too.
But you learned from that mistake.
But I couldn't understand why.
So that is, what's the answer? The answer is they got a contract.
Instead of the buyer's agent.
Say it again, Stephanie.
When he did the withdrawal of the copy of the offer, he sent it to his agent instead of the other person's agent. So that's why.
Yeah, let's make sure
Contract, right? Is it yes?
it's a yes. Hold on, let me walk you through it. Luke Byer made an offer on a tract of land in Leland. Went from Luke the or to the seller the e. Okay, Luke has made this offer on the tract of land. Hasn't received a response from the seller in a few days and decides to pursue another piece of land in the area. He writes withdrawn on a copy of the offer, initials and dates the form, and places it in the mail directly to his agent. So that has not been communicated to the offeree. He has not revoked it. Furthermore, folks, even if he had sent it to the right person, revoking an offer doesn't fall under the mailbox rule. The mailbox rule only falls under communication of acceptance. If you were trying to revoke an offer or negotiate something, it would only apply to when they actually received it. The mailbox rule only pertains to communicating acceptance. Only. So,
Yeah, I didn't catch that till just now.
yeah. So then what goes on is the next day the seller, where this offer is still alive and well, signs it and places a copy in the mail directly to the offeror. Now the mailbox rule has been utilized correctly. We are under contract because that communication was mailed to the offeror or the offeror's agent. That revocation never happened. We do have a contract.
But if they were to email or leave a voicemail, whether or not it's been read, that counts.
Correct. If they had emailed the seller and said, never mind, we take it back. Even if the seller hadn't seen it, if they tried to accept that offer, it would not be a contract because it had been revoked prior to acceptance.
Right, because when you send an email, it's got a time on it.
So you know exactly when it was dead. Yep, that's right.
So, the buyer, Luke, should have communicated directly to the seller agent.
Well, yeah.
Not his agent.
His agent should have then turned around and communicated that acceptance. Understand that this is not an actual training exercise for best practice. It's a training exercise of how to answer a test question correctly. There you go. How about number 4? Lucy Smith is working with a first-time buyer. They have found the perfect home in Wilmington with a great offering price. Lucy presents. Is this about the last question, Adriana?
Yes, I just did not understand why the Luke. Let me just go up.
No, you can't go up. That's my screen, but here you go.
Yes. Oh no, I went on the other one.
Okay.
So Luke, he signed, and he placed a cop in the mail directly to the buyer. So
no, Luke, you're talking about the revocation or the offer?
Oh wait, number 3.
Yeah. But Luke made an offer. Doesn't really say how he made that offer. What Luke placed in the mail was trying to terminate his offer, but he's mailed it to his agent.
Oh no, yes, this part when he signs and places a copy in the mail directly to the buyer. So that's the seller. Sorry.
Yes, that's the seller. The seller communicating acceptance to the buyer, which means we have a contract.
Is it normal practice for the seller to communicate straight with the buyer? I thought, like Tim say, I think didn't they have to communicate through their agent?
Remember, this is a licensing class. I'm teaching you how to pass the test, not how to negotiate real estate.
Okay.
Yeah, no, it is not common practice for the buyers and sellers to talk directly when they have agents. In fact, we only let them talk through us. But that doesn't change how this question is read and how you answer it to get the question right on the test. The whole point is understanding legalities, flows, contract formation, not best practices in the real world. You will not know how to sell a house when you get out of this class, I'm sorry to say. But yeah, we focus on the test.
Thank you.
I know, your brains want to know, but we got to focus on the test, right? That's the important piece. But you're right, that's not common practice in general.
But that's another reason why you get put under a broker in charge, so they can teach you the rights and the wrongs.
There you go.
And what you're supposed to do.
And I'll tell you this, I will teach you all kinds of amazing things to make you ninjas in real estate and post-licensing. That's just not my job in pre-licensing. Yeah. Let's do number 4 now. Lucy Smith is working with a first-time buyer. They have found the perfect home in Wilmington with a great offering price. Lucy presents an offer on the property to the listing agent, who returns it, requesting a larger amount of earnest money deposit. Lucy delivers the offer to her buyer, who wants a few days to decide. A few days later, the buyer notifies Lucy that she has accepted the counteroffer and will drop off a copy on Monday. She fails to tell Lucy that she added a few days to the closing date since we have been negotiating for a week or so. Lucy calls the listing agent and communicates acceptance of the offer. Do we have a contract?
Yes, no, maybe?
No.
This one confused me. I had 2 options that I was trying to decide between. Either yes, but it's potentially voidable, or just no.
Well, and you can't have that many thoughts in your mind, because then you're not going to know how to answer the question. Folks, when you look right here, what does that mean?
That she changed the contract, and you can't change it because that's a counter offer.
There you go.
You can't change it.
They changed it. That is not a contract. It is a counter offer. If somebody puts a strike through and signs it, we need the other party to acknowledge, accept, and communicate that acceptance. They changed the contract, which means they killed the offer as it's set, and they have now initiated a new counter offer. Furthermore, if you say to somebody, we're under contract without knowing that you're not, that's a misrepresentation. You are stating an untruth. So when Lucy calls and communicates acceptance, Lucy just committed a misrepresentation, because she says we've accepted and that we're under contract when in reality we're not. We have got a counter offer. We've got to send it to you. If you change it by $1, it's a counter offer. If you change it by 1 day, it's a counter offer. It doesn't matter how small the change is. That is a rejection and a counter. Everybody okay with that statement?
The way they could have fixed that is with an amendment, right?
Well, in North Carolina, we don't use amendments until we already have a contract. And since this is never a contract, all it is a counter. And folks, the counter offer, as I told you, think of it as a formal strike through. So, let's say the closing date was slated for 3/25. All they would have done is come in here and they would have put 3/28 and they would have initialed and dated that change. And then we need the next party to do the same thing and communicate that they've accepted that change.
Oh, okay.
Mm-hmm.
So if if she did not have changed the days, and it would be a contract.
Sure.
But then she could make an amendment to change the dates?
She could ask for the day change after they're under contract, but remember, even changes, amendments, have to have mutual agreement. So if the seller now said, no, I'm not giving you a 3-day change, you're out of luck. You're stuck in whatever you agreed to. But yeah, if those 3 days hadn't been added and they had signed it with no changes and communicated acceptance, it would have been a contract. But because of the change, it's a counteroffer.
All right, thank you.
Mm-hmm. How about 5? Seller Ryan Jones receives an offer on his property located in Hampstead. He likes everything except the price, so he changes the price, signs the offer, and sends it back to the buyer through his agent. After several days, Ryan receives a call from his listing agent. He is bringing him a full price offer with no contingencies. Since Ryan has not heard back from the first buyer, he quickly signs and accepts the new offer, and his agent communicates this to the buyer. Do we have a contract?
Yeah.
Yes. But he also have another contract that he would be.
Don't use the word. Don't use the word contract. He also has a what?
Another
offer.
Yes.
So what does he need to do?
He needs to send them a withdrawal of his
There you go,
offer.
folks.
Is that a penalty from doing the withdrawal?
No,
No, because it's an offer.
it's an
not a
offer.
contract.
You are always allowed to kill an offer. There's no penalties for killing an offer. So they got the offer, they countered it, so that's a rejection and a counter. And so now the seller's the offeror for this counter offer they've sent off. While they're waiting on a response on this counter, there is a new offer orb that brings a new offer. Those are not overlapping. These buyers don't know about each other. And so this new offer comes in, they sign it with no changes and communicate acceptance. They are under contract with that second buyer. But because that counteroffer is alive and well out there, they need to revoke it. Otherwise, they could end up accidentally getting under contract twice, which is a bad thing. And so if it were me, I would probably send the revocation first and then communicate acceptance to this other one so there was no chance of that happening. Because all it takes is a second to have that screw up and blow up in your face. Pretty good with that one. So the last one that I said potentially get to, and if you did, great. If you didn't, okay. Here's the answer, or here's the scenario. Derek, a listing agent, calls Kate, the buyer's agent, to communicate the acceptance of the buyer's offer. But the conversation goes like this. Hi, Kate. It's Derek. Hi, Derek. I'm so glad you called. Listen, the buyer wants to withdraw their offer on your seller's house because they have found one that they like better. Derek says, well, I'm sorry to hear that, Kate, because I am calling to inform you that the seller has already accepted your buyer's offer. I hope they can decide that they will be happy here. I'll bring you a copy of the accepted offer in a little while. Is there a contract between this buyer and seller?
No.
I said no because in actual physical speaking, they revoked their offer before he said anything. But I don't know if it matters that he's the one that called them.
It doesn't. It is quite literally how you interpret it, folks. It is the wild, wild west of real estate, okay? Whoever shot first wins. Before he communicated acceptance, Kate said, we are taking our offer back. That's it. So there is no contract. She said it first.
Yay.
There you go.
Or
Now, let me throw one more scenario into the mix and then make one more statement, and then we'll move on into another concept, okay? Let me me just find this kind of some blank space. You're not seeing like words on here. Right here. There's some blank space, okay? So I can just talk to you about this. How about Sandeep gives me a phone call. And Sandeep says, Seth, I found you on Zillow and I'm interested in buying a house. I would like to go see 123 Main Street. I say, great, Sandeep. Sounds good. And I meet Sandeep at 123 Main Street. What's the first thing Sandeep and I are going to go over?
Working with realtor disclosure.
Working with real estate agents disclosure. I'm going to say, Sandeep, here's how agency works. Here's the different options. Do you understand this? I'm going to review it with him, and I'm going to ask him to sign it, acknowledging that I've reviewed the disclosure with Sandeep. What's the next step? Say it again.
Agency agreement.
An agency agreement. I've got to represent somebody. The first one was just, here's how it works. Second piece is, let's represent somebody. So I'm going to say, Sandeep, I'd love to be your buyer's agent and represent you. And understand, Sandeep, we can have an oral buyer agency agreement to start with, or we can have a written one to start with. Of course, oral buyer agency agreements are open-ended and non-exclusive. And so I'm going to go over these things with him. And of course, when I reviewed the work of the real estate agent's disclosure, I told him about all the options. And one of the options was, well, you don't have to have an agent as a buyer. You can be an unrepresented buyer. And so when I asked Sandeep, I said, Sandeep, can I be your buyer's agent? Here's what Sandeep says. He says, okay, be my buyer's agent. Great. No thanks, Seth. I'm good. I think I got this down. I just want to see the pretty house, okay? This is a multifaceted learning point here, okay? Sandeep says, no, Seth, you cannot be my agent. Can I show Sandeep the house?
You can, but why would you?
No, you can't.
No, you cannot.
Sure I can.
So I'm going to say yes as a seller sub-agent.
Cool. Yeah, we can. So I can do exactly what Misty just said. I can show Sandeep this house as a seller sub-agent. So Sandeep and I go into this house. Let me make sure I'm spelling your name right, Sandeep. I always got to check. We go into this house and we're looking through it, and he is, loving it, and he's feeling good about it. And we get done looking at this house, and it is Corey's house. And I'm just going to throw another name in here. Kingsley is the listing agent. Okay, I'm just going to put Kings. No, I'm going to put the whole thing because otherwise it just says King. Okay, Kingsley's the listing agent. It's Corey's house. So I show Sandeep this property, and Sandeep wants to put an offer in on the property. Can I put an offer in for Sandeep?
No.
No, you cannot.
Actually, that's a lie.
That's a lie. Sure, I can. I'm not working for Sandeep, but I can put an offer in for Sandeep, can't I?
Yes.
Yes. So I can say, Sandeep, what do you want to offer? And Sandeep tells me, and Sandeep says, okay, well, I want to offer $400,000. And so I write up all the terms for Sandeep, and I send it over to Kingsley. Kingsley sends it to Corey, the seller. Corey looks at it. Corey loves it. He signs it, and he dates it. Folks, at this point, are we under contract?
No.
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 But you were not representing.
Hold on. Wait. Are we under contract at this point?
No.
No. Corey takes this signed offer, sends it back to Kingsley. Are we under contract at this point?
No.
No. Kingsley takes this and sends it back to me. Are we under contract at this point?
No.
Because you're not representing Sandeep.
There you go. That's the learning point here. I've told you since we started this section, communication of acceptance has to be made to the offeror or the offeror's agent. Does Sandeep have an agent? No.
Nope.
I am a seller sub-agent, which means my loyalties are here. If that or an E plane were to be drawn, I'm technically on this side.
Yeah.
So now, if I call up Sandeep and tell him about the communication, do we have a contract?
Yeah.
Yes.
There you go. because Sandeep is the offeror. Now the offeror has been communicated to. When they don't have an agent, the communication has to go to them directly. So that is an important thing. They will try to trip you up on this. Seller subagency, folks, a lot of you told me I couldn't put the offer in. Sure I can. Isn't an offer good for Corey, the seller? I'm not going to represent Sandeep because he didn't want my guidance. He didn't want to hire me. But I can put an offer in. I can show him the property as a seller subagent. But my loyalties are with Corey and Kingsley as a seller subagent. Everybody okay with this statement?
Mostly, I think I need to go back and look at being a seller subagent a little bit more. I don't think I fully understand that concept.
And all a seller subagent is somebody who also represents the seller. And so I told you, you can have a co-brokered seller subagent, or you can have an in-house seller subagent. This would be a co-brokered seller subagent because presumably Kingsley and I do not work for the same firm. And the way you can do this is if the seller and the listing firm authorize it.
So that how are you getting paid?
Don't worry about that. Your answers on your test will never have to do with how anybody's getting paid. Ever. But I told you this in an earlier section. Hang tight. I know y'all are excited. I told you this in an earlier section. It would be in the MLS if I could act as a seller subagent or not. I would know this before I endeavored into it. But I'm telling you, don't ever worry about the money on the test. It will never be the answer.
I guess by that, what I meant is, like, don't you have to be, I guess, technically hired? But that the MLS thing, I guess.
That's exactly how it would say. On the MLS, Kingsley would have put that they are going to work with, compensate, and cooperate with seller subagents and buyer's agents. So either would be okay. All I have to do is look at this multiple listing service and it tells me, can I do this or not? Now, if they say no, then I could not have helped Sandeep in North Carolina.
Right.
Because I have to have a person. If it's not the buyer, it can be the seller. But if it's not either, I'm out. There you go. Now what you got, Adriana?
So if you're not representing Sandeep, then this is not dual agency, right?
No, this is exclusive representation. Two firms exclusively represent Corey. And Corey's best interest only.
Because nobody's representing the buyer.
That's right.
He's representing himself, basically.
That's right.
But this offer you sent, did you send it like?
I typed it up. It's written. It's formal. I sent it.
So you worked for him.
I assisted him. I did not work for him.
Okay.
Let me give you the analogy here, folks. Have you ever been to Best Buy? Anybody ever shopped at Best Buy? What happens when you walk into a Best Buy and you're wandering around aimlessly? What happens in there, folks?
Somebody walks up to you and wants to know, can they help you?
That's exactly right. Now, folks, those people are offering to assist you with anything you possibly could need. Who do those people work for? Best Buy. Just because they're helping you does not mean they work for you. You see the difference there? That's why we call them a selling agent. Just like those Best Buy people are selling you on Best Buy, the person who's working with the buyer is the one who's actually selling the house. But we would need more information to know where our loyalties reside. If I'm a seller subagent, my loyalties are with the seller. If I'm a buyer's agent, my loyalties are with the buyer. Either way, in this scenario, I was the selling agent because I was assisting the buyer.
Yes, you assisting the buyer. It benefits
the seller. So don't ever say that I was working for the buyer. I wasn't. There's a big difference between working for and looking after versus just assisting.
I see. You have an interest in helping him.
Because it helps my seller. Yeah. What you got, Kirsten?
Okay, so kind of similar to Adriana's question, but what if you work for the same firm and you're a seller, but you are now a seller sub agent, but you work for the same firm as Kingsley? Is that then considered dual agency or no?
No. Because dual agency by definition is when the buyer and the seller are represented by the same firm in the same transaction. Even if we took me and I was splattered right here with Kingsley with ABC Realty and we're doing seller sub-agency, there's still only one firm representing one seller. We don't care about the buyer. Sandeep is on his own little island unrepresented. Dual agency is only when the firm represents the buyer and the seller in the same transaction.
Okay. I was just getting confused, I think, because I was still sticking myself with the buyer in that scenario, but I'm not. I'm with the seller because I'm a seller sub agent.
Yep, and that would be true whether or not we were in the same firm doing seller sub agency, doing an in-house seller sub agency, right? Or whether we were in cooperating firms doing seller sub agency. There's still only representation for the seller. The buyer has nobody. So it's not dual. Now this is, once again, as I'm building these layers, right? I'm teaching you new concepts and I'm tying it back into some of these older concepts so that we can see. Now, ultimately, let me throw one more thing in the mix and then I owe you a break. If Sandeep had told me any secrets in the midst of showing that house, what would I have done with those secrets?
Brought him to the south.
Called Kingsley and Corey.
I would have sang like a bird to Kingsley and Corey. I would have told them all of the secrets because I have no loyalties to Sandeep. Sandeep is the idiot who said he didn't need nobody. And remember that working with real estate agents disclosure says, if you ain't going to hire me, don't tell me your secrets because I will use them against you. Huzzah. Folks, go take a break. Come back at 10:45.
10:45?
45, yep.
8:45.
I'm sorry, 8:45. I don't know why I don't, listen, everything just runs together. I don't know what time it is. I think it's because it's a 10-minute break and then I kind of round up. Whatever. Come back at 8:45. Thank you.
Okay.
Thank you for catching me on that. So, we went through several different scenarios with offers and acceptance. Let me make one more statement here before we move into new territory. Please understand that I keep talking about this communication. I keep talking about counteroffers. For the sake of this class, for the sake of this test, you need to think of a counteroffer as something that can actually be accepted, right? It has got the strike-throughs. It's been initial and dated. So when you send it back, all it takes is somebody else accepting that as well and then communicating that back to you. So the other thing that you have to be aware of is that that text message, that email, that voicemail, that communication, whatever it may be, is enough. Okay? It's enough. Doesn't matter that you have or have not seen the actual contract, the actual signatures. Doesn't matter. If it has been communicated, that it has been signed, even though you haven't seen it yet, you have a contract. All right? So let me get this pulled back up here. So we just wrapped up with that question, and then I gave you some more examples. Now this is where I'm just going to remind you as to why some of this is working the way that it's working. And that is the statute of frauds, okay? Not all contracts have to be in writing. Very important to understand that. Not all contracts have to be in writing. But as I've told you in the past, every state has their own version of the statute of frauds, and there are certain documents that we consider sensitive enough to not waste our time in a court if it was not in writing. And I've been naming these: deeds, contracts for the sale of real property, mortgages, security instruments, options, easements, and leases then longer than 3 years in duration. So that means on a test question, if we had a lease that was less than 3 years and it asked if it needed to be in writing to be enforceable in a court of law, the answer is no. If it's a lease of greater than 3 years, it would need to be in writing to be enforceable in a court of law. And this is why that question that Kingsley sent earlier wasn't required to be in writing, because it was a contract for the sale of personal property. It doesn't say anything about personal property. This sale is real property specifically. Everybody okay with that statement? Not every contract has to be in writing. Would you be stupid to rely on a 2-year lease with a verbal agreement? Yes. But that doesn't change the fact that it's not required to be in writing to be enforceable in a court of law. So within the statute of frauds, because these contracts that we're dealing with, for the sale of real property have to be in writing, that's why our offers are also in writing, because a verbal offer really couldn't be accepted because that's not going to be enough. So these are all in writing, and there's something that you're going to be tested on potentially called the parole evidence rule. Okay, I'm going to say it again. It's called the parole evidence rule. And what this basically states is only what's in the contract is part of the contract. So let's say that we have a written contract between buyer and seller. And then outside of that contract, the buyer and the seller negotiate that the seller will leave the washer and dryer for the buyer. Folks, it's not in the contract. It was a verbal negotiation or a written negotiation outside of the actual contract. It's not going to be upheld. Only what's in the contract is part of the contract. What that means is, let's say that buyer and seller are under contract, and sorry, when I freeze up, it's because my kids are doing crazy crap in the other room. I just can't, for the life of me, they just can't try. Folks, if you don't have kids, let me just explain the first 8 years of their lives. It's just preventing them from killing themselves. That is your only job, because they are just 24/7 trying to off themselves. That your whole job, screw teaching them anything, just keep them alive. That's your job, because they just are constantly trying to off themselves. And test your patience. I just want you to know that if you don't have kids. In that scenario that I gave you with the buyer and seller under contract, they've got a written contract, and then outside of the contract, they negotiate for the seller to leave the washer and dryer for the buyer. If the seller doesn't leave it, the buyer has no recourse. It wasn't something that was actually part of the contract. So this parole evidence rule states that only what is actually in the contract is part of the contract. So if you want to add something to it, you better put it in writing, and you better put it in the contract, typically by way of that amendment or some other type of agreement. Now, up to this point, we've been really talking about contract formation, right? The essential elements, how it moves from an offer to a contract. There is this testable concept of contract formation. Well, folks, do contracts end as soon as they're created? No. That's step one. Now you've got to do what you actually promised. I just saw the Velociraptors. Basically, it's funny, Justin, you don't want to know parts of that. I wouldn't trade it for anything, but boy, I tell you what, they are just it's on another level sometimes.
Oh, wait, Seth, because the first 8 years you keep them from killing themselves, but the next 8 you keep them from killing each other.
Oh, well, so I'm actually, mine are already at that phase, but I'm sure that's not going to end. Listen, I am the youngest of 3 brothers, and the last actual physical fight that me and my brothers had, I wish I could say it was in the teenage years. It was when I was in my mid-20s. So, I mean, you know, sometimes, yeah.
I raised 3 boys, and I would come home to full body broken on the walls, like the full body where they'd thrown each other into the walls.
Yep.
Like, I don't know how I survived it.
Yep. Yep. You raised 3 boys. I'm youngest of 3 boys, and I have 3 boys, so I'm gonna get all that too. Like I'm gonna be. I lived it, and now I'm going to have to raise it. So that's not for the faint of heart.
I'm the youngest of 5. I have 3 brothers, and so they're all like a lot older than me, and now that I can go toe to toe with them, it's a different story.
Oh yeah. Back in the day, that's they can really whoop you. But when you're all grown, you're all on an equal playing field typically, so it changes things a lot, right?
Yeah, like 2 years ago, my oldest brother, he's like double my age. I think he's 36. He tried to go toe to toe with me on the beach, and well, he was double my age at the time. He's not technically double.
Yeah, I was gonna say he's not double your age anymore, right? Because of the way the age works. I got it, but that's what I was like. He's not double anymore, but yes.
He tried to go toe to toe with me at the beach, and we both just about drowned each other.
It happens, yeah. That's right. Been there, done that, man. I know all about that. So, the parole evidence rule says only what's in the contract is part of the contract. Of course, as I just said, everything that we've been working up to this point has been contract formation, creation, whatever you want to call it. Well, once you have a contract, that's when the promises you made to each other come into play. We call this performance. Okay, we call this performance. Doing what you said you were going to do. Okay? Now, I'll tell you, one of the analogies that I use sometimes, depending on, my version of slides and stuff, contracts and offers are very much like a relationship. And I'll explain why. I want you to picture a proposal, okay? You got some dashing young man who has the love of his life, and he gets down on one knee and he gives her a ring and he says what?
Will you marry me?
That's exactly right. And that is an offer. Because then, as she's sitting there, she can say yes, she can say no, she can say, I'm not so sure.
What are you offering for me?
Right, there you go. So it's very much just like this contract formation thing. Okay? You make an offer, and if she accepts it, now we're under contract. Well, folks, an engagement is just like that. We're engaged, and it's typically a period of time until we get married. So think of marriage as the culmination. You performed what you said you're going to do. So the contract is formed, then we've got the things leading up to performance, and then the ultimate performance is completed. It is culminated. That is when we are the executed contract. So the engagement period is what we call contract to close in a real estate terminology. Of course, as I said before, you cannot answer these questions only thinking about real estate, because this is true of all contracts. And then when we get to the point where we're actually fulfilling our promises, the wedding or the closing or the whatever the contract ends with, that is how we complete performance. So if you were to answer a question, and let me just give you an example, about performance of a contract. Well, folks, agency disclosure has nothing to do with performance of the contract. Because performance is after you're already under contract. And not every contract has to do with agency or even, real estate. So be very careful. Don't answer, real estate related when all they want to know is, well, what are parts of the performance? Completing your promises. Getting to whatever we promised to each other. So there's a couple pieces of verbiage on this slide in front of us. Let's talk about the first one. Time is of the essence. There are some times that contracts have some wiggle room. And there are other times that they don't. Time is of the essence means no wiggle room. It means the date is the date is the date. The time is the time is the time. Not all contracts are time is of the essence concepts. But if it was important to us, we would put time is of the essence. Meaning you have no wiggle room. If we don't put that, there's typically some other type of, verbiage in there that would help you understand how much timing you may have to complete something. Now, these other two terms is one of those other groupings where if you Google it, you can go down a rabbit hole and get yourself confused real quick. So I'm going to give you the most simplistic version. Take it as I'm telling it to you for the sake of the test. An assignment is quite literally, as it says, a substitution of parties to a contract. So if Tim and I had a contract to sell real property, we're going to be the parties, buyer and seller. The prices are on there, the closing date's on there, all of the terms. We formed a contract, we've made promises to each other. An assignment is where nothing changes on the contract, but we change one of the parties. So let's say that Josh wants to buy this house for some reason. And I let Josh take over the contract. The contract is the same. We've changed one party. Now, instead of Tim selling to Seth for all these prices and terms, Tim is selling to Josh for all these prices and terms as an assignment. You have changed a party, but not the contract. Now, interesting to note, you cannot automatically do that with every contract. When we get into a very specific North Carolina contract, you can't do that without permission of both parties. So sometimes assignments get grouped into subleasing. Really what it comes down to, though, is understanding that, when we assign it, did I absolve myself of liability completely? Am I out completely? Or am I sitting at a secondary level of liability if Josh doesn't perform? Now, that's going to be a little more nuanced, and we'll talk a little bit more about that later. But all an assignment is a substitution of the parties. And let me give you a real world example of this to help your brains. And this is kind of a weird one, but it's true. In the multiple offer situations we were in over the past 3 years with historic low interest rates, okay, people were just beating each other over the heads to get a good house. And so there was very often that there was 10 or 15 buyers on every property. And of course, for every one person who wins, there are 14 losers. Well, sometimes people are very upset about losing on their quote unquote dream house. So they may try to figure out who actually won, and they may come to them, right? So let's just use the names that I gave in the scenario. Josh lost out on the house, and he's very upset about it. And so I won the house. So Josh comes to me and says, hey, Seth, I heard that you won this house. I'll give you $20,000 if you let me take over that contract so I can buy this house. So he's paying me to buy my contract, and I turn around and I assign it to Josh. Nothing changed with the terms. Tim is still getting everything that I promised him. He's just getting it from somebody else. That's an assignment. Everybody okay with that statement? Substituting the parties. Contract's the same. What you got, Tim?
That's like wholesaling, right?
That's exactly what wholesaling is. Wholesaling is selling a contract. We're under contract to buy a house, but we don't actually want to buy it, so we turn around and we sell it to somebody else who does want to buy it, and we make a profit for selling them that contract. That is wholesaling the way that most people interpret it. That's exactly right.
Seth, I don't know anything about this, but like, who would approve this? Like, would the seller have to be okay with this also?
It depends on the way the contract was written. You have to understand that sometimes contracts are written in such a way that we need the seller's permission. Sometimes they are written in such a way where the buyer would say, me or anybody I want to assign it to. And because the seller's already agreed to that, it would give us the right to automatically assign it. Depends on the verbiage in the contract. So a novation is a substitution of contracts. Now, novations have several different meanings, could happen in several different ways, but let me just use, let me give you two brief examples, okay? Let's say, and I'll just use the same names, Tim, and we'll just leave it at Josh. Okay, Tim and Josh have a contract together, and let's say somewhere along the lines, they've amended the contract and they've changed this to $395. They've changed this to April 1st. Then they amended again. Now this is changed to April 6th. They amended again. Now this is changed to April 10th. They changed this back to 400. You don't need to know why or the reasons they may have changed this. But if they were just making strike-throughs and they're amending their contract after it's a contract, not an offer, and they're all in agreement with these changes, these are called amendments. Well, folks, at a certain point, the contract will get really muddy and mucky, and we don't even know what the hell we agreed to anymore. So what Tim and Josh may say, hey, let's just draft up a new contract, agree that that's going to be our contract, and then we will just null and void this one. That would be a novation. We've created a new one that we accept as our contract, and we both agree to terminate the old one. Out with the old contract, in with the new. Parties are the same, but the contract has changed. That would be a novation. Now, there's other ways that novations can happen as well. If, you had a 10-year lease and somebody bought your business on year 5, that 5 years are left on your lease, the landlord may agree to renegotiate with the new tenant and create a new 10-year lease. And so they say, forget your old, 5 years remaining of your old lease. I've signed a new 10-year lease with this new tenant. And so that'd be a novation, substitution of contracts. This one takes the place of that one. The other one's forgiven and forgotten.
Do these happen a lot?
No, not in the real world. I mean, they do happen, right? But no, not a lot.
What could cause an amendment? Because everybody has an agreement on what the terms and the conditions are going to be in the contract. So I guess what would really cause an amendment to be necessary?
Yeah, we're going to talk about that a little more when we get into the actual sales contracts. But let's say in that example, we had a home inspection, realized that the HVAC needed work, and so as opposed to fixing it, we both agree that, Tim would just reduce the purchase price for you. Let's make it a little bit easier. Instead of $400, Josh, how about this? I'll reduce it by $5,000. And so you've got, this discount. Yeah. So but we can't do it without everybody agreeing to it, right?
So I guess when we see signs that say under contract, that would cause an amendment for the actual closing date to change if it's under contract or under review.
If you see the sign that says under contract, that just means we have an executory contract. It means that it has not been completed yet.
Okay.
Yeah, there's nothing that you need to worry about that would cause, dates to change or anything like that. It's just whatever the parties agree to. That's all that's within the contract, whatever the parties agree to. Mm-hmm.
Isn't there like another little sign? I feel like I don't want to say under contract. Like I feel like there's another sign that I've seen.
Pending? Contingent. Under contract. Those are the only ones. There's pending, there's under contract, there's contingent, and that's it.
Okay.
And they all kind of have separate meanings, and I'll touch on those a little bit more later. But yeah, under contract, pending, contingent. For all intents and purposes, that just means you have an executory contract. We're waiting on some things to be fulfilled. It hasn't closed yet. That's what those all mean status-wise.
Okay.
Yep.
Thank you.
Mm-hmm. So, when we're dealing with discharge of a contract, okay, completion, fulfillment, terminating, remember we've talked about ways that agency contracts die, specifically. We've talked about ways that offers die. So now we're just talking generalization under contracts. And so just like when we talked about agency contracts, full performance is the best way for it to die. You completed your purpose. Contract between buyer and seller. Seller sold the house. Buyer paid the money. Full performance. Completed. Done. Best way for any and all contracts to end is full performance. Because remember I told you, what you've promised, fulfilling that promise is called performance. Well, there are times, and I kind of started off this section this way. Do you think there are times that a buyer and or a seller did not get everything that they were promised to get? Yes. But sometimes they just suck it up, buttercup, right? And they just do it anyway. And so if you did not get everything you were legally promised, but you still completed the contract, that is what we call partial performance, also called substantive performance, depending on how much or how little, was an issue. And so, let me just give you an example here. If we read an actual contract that we utilize in North Carolina, that standard offer to purchase and contract form 2T, there is a provision in there that says that the seller has to remove all personal property, garbage, and debris from the property. Says that very plain as day. And so arguably that means that if you get there on the day of the final walkthrough leading up to closing, the seller has left a couple trash bags there, then the seller is in breach of contract. Well, folks, do you think most buyers are going to terminate the deal because 2 bags of trash were left in the yard? They're not going to like it. They may raise some hell about it, but they're probably going to close anyway. It's partial performance or substantial performance. Not every promise made to them was fulfilled, but it did still close. Now, we've used the terminology breach before. So breach is when one party does not fulfill their promises. And I just used that, okay? So the seller didn't remove all the trash. Technically, the seller's in breach. But breach doesn't mean that the contract terminates. It means that the non-breaching party could elect to terminate the contract and seek what we call remedies. We're going to talk about remedies in a minute. But all a breach is you legally did not do what you were supposed to do. It's not the same thing as a termination. It's not voiding the contract, but it makes it it's potentially where one party could terminate the contract. and be entitled to remedies. Now, before we get to the remedies, let's talk about a few more ways that in general all contracts could end, or, the categories. Impossibility of performance is another one. Buyer can't obtain funding. They can no longer buy. That doesn't mean that they're not in breach, understand, but that would make it impossible for them to fulfill it. Seller's property gets foreclosed upon. The house gets burned down. There's a lot of things that could constitute impossibility of performance. It can't be completed anymore. Doesn't mean that there's no remedies to it, but for one reason or another, it can't be completed. It's called impossibility of performance. Of course, we said mutual agreement terminates every contract in the entire world. And then operation of law would also terminate contracts. Eminent domain, government coming in and taking that property, bankruptcy protection, anything like that could end up being court-ordered sale based on some type of litigation. All of these could kill the contract by way of operation of law. Now, folks, I'm going to say this again. This is contracts in general, but I'm going to make a statement, okay? And I'll revisit this when we get into the actual North Carolina sales contract, but I'm going to say it. I'm going to explain what I mean now. I told you that sales contracts survive death. So, if Justin and Misty, seller, buyer, had a sales contract together, not an offer, a contract. Misty was buying Justin's house. Here's where people don't necessarily love this concept, because you always want to know, well, what happened? Well, I don't get it. But let me explain this. If Justin was to die, Justin have already hang tight, Jacob. If Justin was to die, Justin has already made the promise to sell this property to Misty. And so his estate would still be obligated to sell to Misty. These survive death. Okay? So if we had Justin die, even if his kids didn't want to sell it anymore, oh no, we really like the house, we don't want to sell it anymore. If his kids refuse to sell, then they would be in breach of contract and be subject to any remedies a buyer has available to them for that breach of contract. This is what I mean when I say sales contracts survive death. Now understand, I'm sorry, Justin, I don't know why. It's just bad luck, because I'll realize that I haven't named certain names in a while, and I'm like, let me bring Justin back into this. I'm sorry. I have killed you quite a bit in this class, haven't I? Now that you said that, I'm like, it's nothing personal, Justin. I'm sorry. So, sales contracts survive death. The estate of Justin is still obligated to sell to Misty. Most people can grasp that okay, because there's still a house. What's going to happen to the money? It's going to go to his estate, and it'll probably be divided between his kids for whatever's left over after they pay off any debts he had that he was legally obligated to take care of. You know what? I feel like I always do bad stuff to Misty too. Dang it. I'm sorry, Misty. Because listen, I burned your house down after your sisters. I keep picking on all of y'all. I'm sorry. It's just random. I promise. It's just really, So here's where people have a harder time grasping this. If Misty, the buyer, dies, our sales contract is still alive and well. And a lot of people don't like this, because they're like, well, wait a second. A dead person can't buy a house. I know. Trust me. But that's not written into the contract that if you die, you just get out of it. It survives death. So technically, the estate of Misty is obligated to buy still. And when it can't or doesn't, the estate of Misty's in breach. You have to understand that. There is no death provisions protecting this in a sales contract. They will probably just terminate. But listen, what does it matter to Misty if she's got penalties? She's dead. So sales contracts survive death. They do. It doesn't necessarily mean that the contract will go to closing, but we don't terminate it. Folks, think about it. If you have a house that you own while you're alive, and you still owe the bank $200,000, and they have a lien against that house, and you die, are they going to forgive and forget that money you owe them? No. It still has to be paid. And that's another part of probate. If that house gets sold, they get their money first before your kids get anything. So part of probate, part of your estate settling is paying off your debts that you're still legally obligated to pay. The contracts that don't die when you die. Promissory notes and liens survive death too. So we're talking about all these contracts, and I told you, if you don't do what you promised to do, that is what we call a breach. Okay, it's called a breach. You are not doing what you said you were going to do. And so a breach typically opens you up to penalties. And we call those remedies. Remedies for the non-breaching party. And there are certain things depending on the type of contract. So there is what we call monetary damages. Monetary damages is a financial remedy, going after you for money. Well, let's talk about this first one. Let me emphasize the word here that you need to know. One of the monetary damages is called compensatory damages. Think of the root word to compensate. This is where we ask you to return us to the financial position we were in before you done did us dirty. Well, I spent $5,000 on this, and I spent $2,000 on this, and I lost this much because of your breach of contract. Refund me the money I've lost. Make me whole. Compensate me and return me to the financial position I was in. It is identifiable. Here's what I've lost. Reimburse me. That is called compensatory damages. Now, there's another one that we're going to get into in a second called consequential, which is a money damage. But before we get to that one, let's talk about liquidated damages. Liquidated damages, folks, are a pre-negotiated amount. It says, okay, we're entering into a contract, and if I mess up on the contract, here's what you'll get. We have pre-negotiated it. If I mess up, here's what you get. It's called liquidated damages. Well, on our sales contracts, earnest money is an example of liquidated damages. Because we have negotiated this amount that sits in an escrow account, and if the buyer was to breach contract, the seller would be entitled to that as liquidated damages for the buyer's breach. If I mess up, here's what you get. It's called liquidated damages. Earnest money is liquidated damages. We're going to talk more about earnest money on the actual sales contract. Hang tight. So then we got one more financial or monetary one that we need to throw in the mix. And that is consequential. Think once again of that root word. There's consequences. Consequential. So in consequential damages, I want you to think about Johnny Depp and Amber Heard. Folks, when she went nuts and said all these things about Johnny Depp, if you remember those trials that we're all so intently looking in a couple years ago, he didn't actually get money taken out of his account. There was no money lost except for court costs. But what he did is he lost out on jobs because of her, accusations, which ultimately led to a huge future loss of profits. And so when he won in court, she was ordered to pay back consequential damages, lost profits that may not be necessarily identifiable, but we say, okay, you've definitely caused some future lost profits, and so you're going to pay consequential damages. Now, let me give you an example of this in real estate. If somebody tries to sell you something as a turnkey Airbnb and you purchase it, close on it, thinking you're going to have rentals off the bat, turns out that it's in violation of permitting and you can't do it for another 6 months, you could sue them for consequential damages because you have lost profits that you were promised. The next one on the list, very important, it's called specific performance. Folks, what is performance within a contract?
Carrying it out.
You're what?
You have to do something.
Carrying out the terms and the conditions of the contract.
There you go. What you promised to do. The things you said you were going to do. That's your performance, right? There's contract formation. And then once we form the contract, do what you said you're going to do. That's performance. And so specific performance is a lawsuit that doesn't seek money. It's where you go to Judge Judy and it's where you say, make them do what they said they were going to do. Speaking of kids earlier, right? It's like when one of your kids like gets in trouble. It's like, I'm going to tell mom and make her make you give me a turn, right? It's just like that. It's where you go to Judge Judy and you say, make them do what they promised to do. It's called a suit for specific performance. Now, folks, under basic contract law, a suit for specific performance is for anyone. However, when we get into, and this is where I told you there's sometimes very specific contract discussions. When we get into the North Carolina specific contract that we talk about, the Standard Form 2T, specific performance is only a remedy available to a buyer, not a seller. A buyer in North Carolina using the 2T could sue the seller for specific performance and force the seller to sell them their house if the seller tried to back out of it. And it's not that hard of a lawsuit to win because of that uniqueness. We talked about uniqueness on day one. Real estate is unique. So specific performance is a lawsuit to force them to do what they said they were going to do. So the rescinding the contract, folks, for all intents and purposes, you can think of rescinding the contract basically as voiding the contract. When I'm talking about these remedies, we are basically saying, okay, we had a contract, you did something wrong, and now I'm potentially going to be entitled to these remedies. If you were to rescind the contract, you're basically not saying that we had a contract. You're basically going back to say, okay, let's just pretend the contract never existed. So rescinding the contract is typically associated with no monies have happened yet. We basically just rescind it. We say, okay, let's just pretend it didn't happen. So we're not going after money. We're not going to court. We're not fighting where there's no partial performance. To rescind the contract is to basically go back and say, okay, let's just say we didn't have one. Because if you rescind the contract, you're not entitled to remedies anymore. Because to rescind it means we're agreeing that we didn't have one in the first place. Stephanie, I saw that. Stephanie's just... I can see when the anguish starts to kick in on you folks. I can see it. I know. You know, as I sit here, and I just think about the years I've had in the real estate industry and the years I've had as an instructor to get to the point I'm at, and then I think about how much I have to cram into y'all's heads in this short period of time. It's just, it really is cruel and unusual. I mean, it honestly is. Folks, that being said, I will send you the link to those database of questions if you want it. Great. If not, reach out to me if you need anything. Ask me questions in the group me. I will try to answer them so that way they can help everybody. Make sure you're studying, going through the materials. If it can help you in any way, let me know. Have a great time away from me. I will see you all next Monday to do it all over again. Whoop, whoop. Have a lovely night.